Let's go to the courts now, where Senior Counsel Advocate Geoff Budlender has argued before a full bench in the Pietermaritzburg High Court that the private prosecution of Advocate Billy Downer was without substance and should be set aside. Former President Jacob Zuma instituted a private prosecution against Downer in September last year for allegedly having leaked his private medical information to News 24's legal journalist Karyn Maughan. Budlender says Downer has not made any such disclosure, neither did he attempt to conceal it, nor was he an accessory after the fact, as was claimed by Zuma. Budlender says the prosecution of Downer was an abuse of court process and was part of Zuma's delaying strategy since 2007 to prevent his arms deal trial from going ahead. Let's get more on this now and speak to legal analyst Mpumelelo Zikalala. Thank you so much for your time this evening. Before we even get to some of the arguments in court, it's nearly 18 years later. Can we ever get to a point where this particular matter sits down for trial?
I think we're close to the end. I think all the legal avenues that can be traversed are nearly done. And it's only a matter of saying that when things go back to normal, you then say, let the first witness go into the witness box and then you'll be able to deal with it. However, there are other avenues that can still be there. There are a number of things that you can be able to challenge up until the court. It should be up to the trial judge, who then say, I'm not going to tolerate any disturbances which are going to take place. I'm continuing with the trial regardless of your complaints. And if you feel that you've been hard done, you can always make your plea as you move along and maybe apply to the SCA for the trial or for your clients to be dismissed if there are certain injustices that have taken place.
And that would be very interesting, should that development actually happen, as maybe we could even see an application to try and halt the process. But let's go to today. On the private prosecution, of course, Advocate Geoff Budlender arguing, that the private prosecution is without merit, is unsubstantiated, and it's merely to delay this particular prosecution. Let's talk about your thoughts on some of the arguments that were presented.
Well, I think one thing we must understand, and what I think was the team of the former president are going to say tomorrow is to say, there are processes in law which are able to deal with this type of concerns. Now, private prosecution is a concept which has been there, it is legal. If you go into the Criminal Procedure Act, it will tell you how things are done. It then opens up an avenue of saying that this particular dispute resolution process, which is criminal in nature, must then be handled in a manner in which all criminal matters are handled in. Now, if you then look at the defenses that are there on anyone who is prosecuted, whether it's by private prosecution or not, there is a defense of saying that you do not have charges to prosecute. Now, the question would be, in which the courts would have to answer, if you have a perfect dispute resolution process that enables you to provide a defense in which they are providing now, why do you want to circumvent or short-circuit the process and deal with it within civil proceedings when within the Criminal Procedure Act, there are ways and means of providing the defense? The minute you go into the merits of the matter, then to me, you are saying you should have answered all those merits when the main trial has started. If you are discrediting or maybe have inquiries with regards to the certificate that was issued, then I would understand, because the question would be, let's check whether the certificate is authentic or not. Let's check whether it was issued by the appropriate individual. And maybe within those civil proceedings, then I could understand. But on these ones, I think the court is going to have a hard time, of course, subject to what the former president's legal team is going to say tomorrow, in terms of saying, how then do we distinguish between these two processes? How then do we distinguish and do not belittle the criminal proceedings which need to take place at the end of the day? There are ways and processes which are available in our law to deal with private prosecution, deal with the legal arguments and the merits of the matter within those processes. Don't try to short-circuit the process by engaging in civil proceedings.
But how big is this issue of the Nolle prosequi certificate? Because it came back again, and the argument stands for this particular legal team, of course, saying that it wasn't specifically issued against Maughan, and really how much of a big headache is this going to be going forward?
It is, but then we must then throw the ball at the NPA, because they are the ones that issue this particular certificate. So they're the dominant leaders when it comes to how those certificates are drafted, who the certificate is against, and who then you can be able to prosecute at the end of the day. But even when that being said, the person or the defense in which you are going to provide, of saying you do not have charges to prosecute, must come under or be used when you're exercising your rights as per the Criminal Procedure Act and not in civil proceedings. So if I have been charged, I must then go to all the criminal processes that anyone would go to, and when the time comes to file my plea within those criminal proceedings, the title to the prosecutor is going to be stated there as it has been stated within the Criminal Procedure Act. Now, to try and deal with civil proceedings, you are going to create a very bad precedent in which, in the near future, when anyone is being prosecuted in South Africa, they're going to say, before you issue that arrest warrant and you say I must go and appear to court, I'm going to institute civil proceedings and go and question every single legal thing that you've done in that particular docket to check whether it was above board or not. Now, creating a dual system when it comes to the court processes that must apply, extending the amount of time in which justice will have to be solved, extending the amount of time in which the quality and the quantity of the evidence can then be extricated or be used. Because if people die and if evidence is lost, it decreases the chance of me being found guilty at a later stage. So the courts must be very careful in this stage, and respectively so, to not create a very bad precedent of creating two or dual systems. If a particular process or legal system or process has been available or is available in law, allow individuals to follow that process, do not create a dual one, because they're going to create problems.
It sounds then like it's a bit of a rock and a hard place, though, as you're explaining it, that the court is finding itself in.
But the courts can easily solve this particular matter and ask this question. With the type of complaints that you are coming to in court, is there an appropriate legal system that one can traverse in order to deal with that dispute? If the answer is yes, then you're in the wrong place. Now, in this case, if you say you don't have any merits in the private prosecution which is taking place, then the question would be, is there another place in which you can raise a particular defense? The answer is yes. The Criminal Procedure Act is very specific and says, in the number of defenses that you can say, apart from saying, I'm not guilty because I did not partake in whatever criminal activity that has taken place, there are a number of defenses that are there, including the saying that you do not have a null prosecution certificate or you do not have charge to prosecute. And it's a subject that has been traversed before. So the courts must simply go back and say, we are not going to adjudicate or create a dual system. Yes, we have an avenue which is available to you, and we have inherent jurisdiction as the High Court. However, what you are not going to do is to look down on the provisions which have been created in the Criminal Procedure Act and allow those provisions to be circumvented by civil court proceedings. We are going to instruct you, or we are going to dismiss your case here and say whatever arguments that you are raising here ought to have been raised when that private prosecution process has already started. Even for Ms. Karyn Maughan, if you then say you do not have time to prosecute at the time, or maybe do not have the certificate which is required, provide your defense during those criminal proceedings and not during civil proceedings. Do not create dual processes of things which need to be adjudicated or can be adjudicated by a well-articulated precedent or legal system that has been used and tested a number of times, and which is applicable legislation that has not been abolished by any court.
Sounds like a fine line that the court is going to have to walk here. But let's see then what happens with the other part of the arguments here and how they respond to some of the issues that have been raised and that the court has also asked them to be able to then clarify. But let's leave it there with you and see then how the other party fares. And we then hopefully have a conversation around that. That was legal analyst Mpumelelo Zikalala, of course, taking us through some of the proceedings that we saw today at the Pietermaritzburg High Court as former President Jacob Zuma continues his bid for private prosecution.